Hello, friends. Welcome to this class. This is Introduction to Law and Governance. We have previously looked at the Constitution as a source of law. So today we want to look at another source of law, which is a case law. Under case law, we've got common law and doctrines of equity. We also have a customary law, that is the African customary law. We also have Islamic law as a source of law, and we shall be looking at this in our class. Therefore, fast forward, let us look at what our objectives are. So our objective, number one, is to equip the learner with knowledge, skills, and attitudes that will enable them apply the principles of law and legal systems in an entity and ensure compliance with basic principles of governance and ethics. So what are the outcomes we expect? So if you are to pass this paper, one thing you'll need to be doing is that you need to demonstrate knowledge of the essential elements of the legal system. You should also be able to demonstrate knowledge of legal personality, who is a legal person and who is an individual. So you need to know all of this. You need to be able to apply tort and contract in various scenarios. We're going to look at that. You need to be able to apply general principles of business law in practice. So general principles of business law can even include practices that have gained notoriety. You need to apply the fundamental principles of ethics in practice. You need to also comply with fundamental principles of governance. Fast forward, let's go to case law or judicial precedent as a source of law. So judicial precedent has also been referred to as a judge-made law. So the question becomes, in your understanding, do you think judges make the law? It has been said in the past that it is lawyers who have tried to convince other people that case law is judge-made law. So basically, when you have lost your case and your client is disgruntled, so you're trying to explain to them that I did not advise you on this area because it is a new area that the judge has made a law on it. So that has been made to look like one of the arguments. So do judges make law? We're going to see whether they do. So precedent is basically applying principles as they have been applied by another court. This is under the doctrine of stare decisis. So only the High Court, Court of Appeal, and Supreme Court are able to create precedent. So the magistrates courts, these tribunals don't make precedent. Courts martial don't make any precedent because they have no other lower court to bind. So the High Court binds all the lower courts and tribunals, that is the subordinate courts, magistrates courts, tribunals, rent restriction tribunals, and other tribunals. We have the Court of Appeal. So the Court of Appeal has power to bind the High Court, and it also has power to bind all the tribunals and power to bind the magistrates courts especially. We also have the Supreme Court. So the Supreme Court basically binds all the courts in the country except itself. So the Supreme Court is allowed to make a decision today and depart from it tomorrow. So it binds the Court of Appeal, the Supreme Court that is, binds the Court of Appeal, it binds the High Court, it binds the magistrates courts, and all the other tribunals that do exist in this country. So when we're looking at case law judicial precedent as a source of law, there's one major aspect we're focusing on. And this aspect is called ratio decidendi. So ratio decidendi is the main reason where a judge takes a specific view in a case and makes a decision that will bind all other lower courts. So the court will say, for example, that in trespass is actionable per se. The moment you step on someone's land, it becomes trespass. So if the Supreme Court says that, then basically it binds all the lower courts. That is what now becomes ratio decidendi. It is the main reason why the judge took a specific view. So in this case, it will be the main reason for taking that view would be that someone stepped on that property, and therefore stepping on the property makes it become an action for trespass. If the Supreme Court says that votes in a presidential election, the moment they are tallied at the place of voting, they become final, then that becomes the law everywhere. If the court goes far ahead as to say that its decision in a presidential election also applies all the way up to members of county assemblies elections, then that becomes election law. That is what decides all other cases that are before the courts. So the ratio decidendi is on one part. That is the main reason why a judge took a particular view. And normally, you'll find that parties have raised it in their pleadings, say in the plaint and in the defense, that issue has been raised by parties. And then the judge takes a view from the pleadings of both parties. However, the judge can make a comment, not a main reason, but a comment on the case. Now, this comment is a mere observation of the judge, in which case we call it an obiter dicta. Obiter dicta is aside from the ratio decidendi. Ratio decidendi is the reason for deciding, but obiter dicta is a by the way, a comment, an observation. So the court might say, for example, that election results in any event should not be tallied for more than 3 days. So if parties had not submitted on that issue, had not brought that issue before the court, and judges do it merely as an observation to say, to promote sanctity of our elections, let us just ensure that we have tallied our votes in the first 3 days after the election. So it becomes obiter dicta. We're going to see the importance of this. This does not bind other courts below it, but we're going to see its importance. So it is important because whereas it does not bind, it is of persuasive nature. You can use it to persuade a judge of these other courts, or even the court that made the observation. You can use it to persuade the court and tell them, the Supreme Court thinks of it in this manner. Don't you think we should take that view? And if that is an area that the Supreme Court has not specifically made a ratio decidendi on, then that court will be at liberty to follow this obiter if it persuades them. So you need to raise it as a persuasive argument. Persuasive arguments are like those times when you'd ask your parents to buy you a toy. It is at the point when you persuaded them enough that they would buy the toy. You make them see where you're coming from. So you can use this obiter dicta to go to a judge of another court and tell them, if the Supreme Court really thought of it like this, then there has to be an importance attached to it. And when a judge sees that, it is likely that they are going to take the same position if you persuade them enough. So, as we're saying here, is that if the court below finds it to be good reasoning, they will be able to apply it to solve the dispute at hand. If they do find it to be good reasoning, they are likely to apply it to solve the dispute at hand. And this helps in matters where there is deadlock. Statute does not provide for it. There is no other case law that provides for it. Then the court will use it and feel persuaded to make a reasoning that will resolve the dispute at hand. There's also a smaller aspect. There's also a smaller aspect called declaratory precedent. So declaratory precedent, this is where, the rules already exist probably in statute. The rules already exist, say, in the Election Act. And now all the judge does is to declare it that this is the law as has been shown in the Election Act. So once the judge says that, it is called a declaratory precedent. The judge did not make it from his own reasoning as that pronouncement to be the law, but the judge simply looked at what the law is as it is provided in statute or in the Constitution and said, well, this is what the law is, sometimes copied and pasted in the judgment. And we'll say, this is what the law is. So that is merely declaratory precedent. It hardly went into the judge's mind and came out. It is just pasted as, this is what the law is, and this is what we are going to follow. So, as we've said, the Supreme Court does not bind itself by its decisions. It, however, binds the Court of Appeal and all other courts below the Court of Appeal. That is the High Court, Magistrates Courts, and all those tribunals that are subordinate to the High Court. The Court of Appeal also doesn't bind itself, but it does bind the High Court and those other courts and tribunals that are subordinate to the High Court. That will be the Magistrates Courts and the tribunals. The High Court on its side does not bind itself. It is allowed to depart from its decision, but it binds all other subordinate courts. And this binding in the High Court means this. A judge of the High Court, once a judge of the High Court decides on a matter, all other courts below it are bound by that determination. Now, there are decisions in English courts. So these decisions are not binding, are not specifically binding on courts in Kenya. However, courts can apply them whenever they are compatible with the issues that arose. So if it was decided in England that goats are domestic animals, and really goats are domestic animals even in Kenya, it will be highly likely that the court is going to apply that decision and resolve the dispute at hand. You see, the whole idea is to resolve the dispute at hand. So where a court finds it helpful to apply an English decision, they will apply it as long as it's compatible. But this application doesn't mean that they are bound by that decision. It only means that they are persuaded by that decision. Well, case law has advantages and has disadvantages. So we'll start with the advantages. Number one is certainty. So even for us advocates of the High Court, where you have seen it pronounced by judges, when you've looked through case law, you've done some research, looked through case law and said, this is the determination of the courts. You're able to advise your client and tell them, this is what happens at this instance. So it is certain, it is known. To you, the lawyer, it is known, and therefore you are able to speak with confidence to your client on that area and tell them, this is the law as the courts have said it to be. And you'll be right because of this certainty aspect. We're going to look at what certainty turns into on disadvantages side. Possibility of growth. And one advantage of possibility of growth is that today the court decides in a certain manner, and then 10 years later, the court will decide in a different other way. For example, in the recent past, it was very hard to register a transgender person until a judgment by Justice Lenaola came in to say, please go to Parliament and change the law relating to registration of persons and include an area that either is not indicated what it is or a transgender area. So possibility of growth, it helps the law to develop. It helps the law to grow, which is why the Supreme Court in Raila 2017 decided that once voting takes place, the election officers are not allowed to make any changes. That is, the form that is filled at the polling station is the same one that is supposed to be used in tallying the total votes. So the law developed in such a manner. The law grew in such a manner. So possibility of growth is a very serious advantage of case law. It is also rich in detail. I'm going to tell you this is true for a fact. Because one thing that happens is that people go out there and make decisions, take part in business transactions of different natures in the petroleum sector, in the area of manufacturing, in all these other areas, fishing, all this, tax, and then it goes before the courts. So when you look at case law, you'll find it has something on tax, it has something on VAT, it has something on pay as you earn, it has something on matters customs. So it is rich in details, and it goes into the specific details of the transaction and decides from that transaction, it decides what the law is there. So it will be rich in detail because it decides on several aspects of the law that it is so difficult to find an area that the courts have never touched regarding case law. Over to disadvantages. So one disadvantage is that it is rigid. Rigid in the sense that you probably have a wiser judge at the High Court, at the Court of Appeal. But since Supreme Court has declared what the law is, they're not able to apply their minds accordingly, or even a magistrate. People have different levels of intelligence. And it doesn't mean that the magistrate is less intelligent compared to the judge. So sometimes the judge can decide in a manner that is wrong, but as long as no one has appealed or overturned that decision, it's going to apply. And it is going to be rigid because the judge is not able to apply his mind accordingly. So whereas on the advantageous side is that there is certainty, there's also this aspect of rigidity, that the judge finds himself bound by a reasoning that he or she doesn't specifically subscribe to. So there's also oversubtlety. Oversubtlety is to mean that it is so easy to evade a reasoning that you do not accept. So judges will look at it and say, well, these facts it is so easy for a judge to look at the facts of the case and say, well, I have seen distinguishing factors that will change my reasoning on this area. We'll say, well, the facts, I see the case that the judge of a superior court to that judge has declared, but the judge will say, but there's a problem. The facts of this case are not an exact match of the other case that the judge had decided. So oversubtlety will come in because the judge is able to artificially create some amount of distinction in the case, and therefore be able to avoid that decision and replace it with a decision that he or she thinks is better. The other one is bulk and complexity. It is true that case law is bulky because there could be like 100 decisions on the same issue. And now, for you to get the proper position of the law, is that you're going to look through most of this. You have to look through sufficient of this in order to make a very well-reasoned decision. So it is bulky and it is complex. This is opposed to other written laws. For example, in statute, it is always indicated clearly what amounts to murder. That is so clear. But now you go into cases, into case law, you'll find now each judge taking a different view, each judge taking a view that he ascribes to. And therefore it becomes complex compared to simply reading section 204 of the Penal Code. Now, question. We're asked to describe two types of judicial precedent. Two types of judicial precedent. So there's precedent that is binding, as we have discussed. We've also said there's precedent that is persuasive. And we say binding is that which the court above has decided in a manner that we refer to as ratio decidendi. It is the main reason why the judge decided a certain case in a certain manner. So it therefore becomes binding on the other courts below it. However, across those courts, for example, which is the High Court that made that decision, since it does not bind itself, it is going to be persuasive. On the other hand, it can be persuasive if it was made in terms of obiter dicta, a general observation of a judge of any court is going to be persuasive. If it applies to the present conditions, then it is persuasive. Decisions of England courts are persuasive. They don't bind that court, so they're going to be persuasive. If you borrow laws from India, a decision of a court in India or China, it is going to be persuasive rather than binding. It doesn't say it doesn't apply. It might as well apply, but it will be of persuasive nature. So we're also told to highlight 3 disadvantages of case law as a source of law. So we've already discussed this, that it's bulky and complex. We've also said that it is easy to evade case law. So we've said that there is over-subtlety. And we've also said that it is rigid, because it is very hard for a court on another side to change what was decided on this other side. The judge is not able to apply his mind correctly because of a decision that was made there before. Now, we are done with the case law as a source of law in Kenya. Now we're going to look at the doctrines of English common law and equity. You can call it equity, you can call it equity. So we will also look at how common law and equity developed in England. So in accordance with Section 3 of the Judicature Act, the first source of law we have is the Constitution, which is followed by written law in terms of statute, not written law in terms of case law, in terms of statute. Below that, what we have is the substance of common law and the doctrines of equity. So these are recognized as sources of law in Kenya, and they do apply up to the extent that courts find them applicable. So where the Constitution is silent on a specific provision, and the statute is silent on what would apply in a specific scenario, then the courts will go down to now common law and the doctrines of equity to make a decision therefrom. Now, common law is mainly used under torts and contract, because you see, there is hardly any legislation that regulates torts and contracts. When you have the Law of Contract Act, whose the main provision that is applied in courts is that contracts in land need to be in writing. However, it leaves most of the provisions are left to common law for decision making. So there is very little, very little legislation or statutory law or even constitutional provisions in the area of common law, which makes it necessary to go down to common law. And common law is a very good decider of the laws in torts and the laws in contract. Now, common law originally used to refer to the law that was not just applicable in one area, but it was applicable in the whole of England. So it was referred to as common law just because it was common in that area, just because it applied in a vast area, in the vast area of England. However, that is not the definition of common law as we know it now. So in England, what used to happen is that even if it is in statute, even if it is written in a specific act of parliament, it could be called common law just because it applied over the whole of England. So only for that reason, it used to be called common law. And as I've said, that is not the definition we know of common law today. So never write this in your exam. So statutory law cannot be referred to as common law. However common it is, even if the Traffic Act applies in the whole of Kenya, you cannot call it common law. Even if your cultural practice is as common as it can be, it can never be referred to as common law. Also, be careful not to describe equity as common law. So the doctrines of equity are not doctrines of common law. They are very distinct. So common law is referred to as the law aside from legislation that originated from the ancient customs in England and was developed by judges on the principle referred to as stare decisis. And stare decisis, its literal meaning is that you are supposed to stand on the decision. So do not disturb what is undisturbed, just stand on the decision. If it has been decided in this manner, just decide it as it has been decided in the past. Just stand on the decision. So common law is based on common sense, as the judges deemed it to be. So they would apply common sense and say it is common sense that this and this should happen. And therefore that is what becomes now the law. Even in our day-to-day, judges apply common sense in some scenarios. And when they do apply that common sense, that is what now becomes what the law is. So in matters such as business law, common sense is very important. So for example, if you're transporting tomatoes from someone, for someone, you're supposed to bring them to Marikiti or Gikomba. So one thing you're going to realize is that if the lorry that you're using stalls, it will be common sense that you are going to sell these tomatoes to someone else. They're not yours, mind you, you're just transporting them. But it is common sense that if you are not able to reach the owner of these tomatoes and they're of perishable nature, so you're going to sell them and account for the profit. And it's also common sense that you're not going to make a secret profit out of it. Now, this is common sense, but it has made its way into Kenyan law. So what are some of the common law remedies available to a party? Common law will give you damages. It hardly has any other remedy. It's going to give you damages. So it is going to look at what damage has been suffered, what injury has been suffered. Say if it's trespass to the land. So it is going to make the person who trespassed to the land pay for that. If it is assault, in terms of tort, it is going to decide that you get paid for the assault. If it is a matter of defamation, the law is going to decide you defame this person, you pay such an amount of money. And so what they're going to look at is the previous decisions by judges in that area. They look at this, if it's the case of defamation of a politician, they're going to look at this politician and look at what other politicians have been given in terms of damages. So if it's, say, a governor of a specific county is awarded, say, 10 million in terms of damages. So it will make a lot of sense to make a similar decision where it is a case of defamation of another governor, county governor. So judges are going to look at the conduct and the previous decisions by judges, and they're going to find what in their mind amounts to the best award in that case. So parties will submit to the court, parties will do submissions, parties will send their pleadings to the court, and the judge is going to look at what each party has proposed in their submissions as sufficient in terms of damages. And then you'll ask the court to stand on the decision of the other court and make a decision. So this is important in torts. If someone is run down by a motor vehicle and this person gets a fracture, the court is going to look at other cases in which fractures were suffered by someone else. So what they were awarded is going to be sufficient to award this other person because the facts have similar cases. The nature and the extent of the injury caused will likely be the same. So when maintaining the decision of the other courts, superior courts, the judge or magistrates will have upheld the doctrine of stare decisis. By standing on that decision, maintaining it, that is now what we call stare decisis. Court is also likely to award interest on the damages. So interest is basically common sense that if you had this money today, you would have the option of investing it. And therefore, the principal sum that is going to be awarded by the courts has normally gained interest, and it is therefore supposed to be a case where you can be awarded interest on the damages. Now, the common law courts in England, in the past, they had about 3 courts. So the first was the Court of Exchequer. And the Court of Exchequer dealt with matters taxation. There was a Court of Common Pleas. This was a court for matters of civil nature and matters of land. So if you look at the Court of Exchequer dealing with matters of taxation, what we have today is the Commercial and Taxation Division, Commercial and Tax Division of the High Court. Now there's a Court of Common Pleas for matters civil nature and land. So we have the High Court Civil Division in Kenya today. We also have the Environment and Land Division, Environment and Land Court rather. And the Environment and Land Court is one of the special courts prescribed in Article 162 of the Constitution. Then there was the Court of King's Bench. This one dealt with matters of criminal and civil nature, where the Crown was a party. The Crown in this matter refers to the King. So the King would sit in these courts, which is why they were referred to as King's Bench courts. So we have criminal courts today. We have, in Nairobi, there is that separation between criminal and civil courts. In other stations, it is highly likely you're going to find the same court that hears the criminal matters will hear the matters of civil nature. And matters of civil nature where the king was a party can be matters like administrative law, judicial review, and matters like petitions for petitions for orders of a constitutional nature. And we have those divisions in our courts today. So, question, explain the meaning and term common law. So this is the law that was developed by the courts in England based on common sense and ancient practices in England. So that is the short definition of the same. So in your exam, you're supposed to demonstrate an understanding of what this common law is, and you're going to go further and say that today common law is important for reasons that it is applicable in matters of contract law, matters of tort mainly, and it helps courts decide based on the principle of stare decisis. So if you're explaining common law, kindly don't leave out the doctrine of stare decisis. So which basically means that you're telling the court to stand on its decision, on a decision that has been made by another court. So you're telling him to stand on it. Do not disturb what has not been disturbed. So when you find that in your exam, kindly apply it as it is. Now, question number 2. Damages are a common law remedy available in torts and are awarded and are intended as compensation for a plaintiff's loss. In relation to the statement, describe 5 categories of damages available to the plaintiff. So damages in this sense are divided into about 5 areas. So the first is general damages. So general damages, I think we have discussed this, is that general damages are those that you present your claim to the court, but you do not know how much is supposed to be paid to you. You can have an estimate, but you do not know how much it is. So for example, in a matter where someone has been run down by a motor vehicle, could be fatal or could be leading to personal injuries. So in that case, what you're going to do is to present your papers to the court, your claim to the court, tell them you suffered a fracture in a road traffic accident. And the court is going to look at similar cases and award you accordingly. The same would apply if it is matters like defamation. So these are torts. In matters like defamation, it is going to apply. In matters of trespass, it is going to apply. Then we have specific damages. These are those we also refer to as liquidated damages. Liquidated because by the time you're presenting them to court, you know how much it is that you want. Correct? You know how much it is that you want. So you're coming to court to tell them, award me this specific amount. So if you had a contract where you supply some goods whose value is 100,000 as you agreed, so you're not going to tell the court to give you the general damages. Whereas you can ask for general damages for that, which is rare to obtain in a matter of sale of goods. You're going to ask the court, give me this specific amount. And specific damages, also called special damages, these damages are required by law that where you're asking for them, you need to have them specifically pleaded and specifically proven. So you're going to tell the court, award me Kenya shillings 100,000. So you need to be very specific about that. You need to be very sure about that. And then the court will look at your pleading where you've justified why you're asking for the 100,000, and look at your evidence. If you had an agreement for sale, they're going to look at it and see where it is written 100,000 is supposed to be paid to you. So at the point when they find that is when they're going to pay that. Now, aggravated damages, which is the third, these are damages that are paid on top of the other damages that court awards. So say if the nature in which someone has acted has been harsh, has been high-handed, for example, has treated someone in such a manner and caused losses to your business, serious losses or an economic shock, the court is going to award aggravated damages. And this is very rare. So you need to show the aggravating factors that make you require damages that are more over and above the general damages and what has been awarded as specific damages. We also have punitive damages. These ones are awarded where there is malice. There's a case in courts of England. I'm going to find the citation. Is that someone drove a motor vehicle and it landed on someone's foot. The vehicle's tire landed on someone's foot. So what happened is that initially this driver did not know that it had landed on someone's foot. When it was notified to him, he maintained the car in the same position. He did not take any step to roll it away from this other person's foot. So it was decided that since he had acted in a malicious manner, in a badly intentioned manner, then punitive damages were to be awarded so that this person is deterred from this kind of conduct going into the future. Then we have nominal damages. Nominal damages, these are usually of very little amounts of money. Can be given about 30,000, 25,000, 50,000 nominal damages. So the purpose of nominal damages is just to show that you have been injured, that you have suffered a wrong that is understood in law, that is known to the law. So these ones, you can get awarded this. So the idea is to demonstrate that you have suffered injury and therefore you're supposed to get a payment for the same. Now over to Doctrines of Equity. And before we get there, so there's an inherent problem that is with common law. The inherent problem with common law is that it only provides you with damages. It does not have any special remedies that are specifically tailor-made for specific problems. We're going to see this. So Doctrines of Equity, also known as Equitable Doctrines. So regardless of how it comes to your exam, they can even be called Doctrines of Fairness. So equity is fairness. So even if in the exam they're referred to as Doctrines of Equity, or known as Equitable Doctrines, or Doctrines of Fairness, they refer to the same thing. So these ones were developed by courts of chancery before 1873. And the reason why they were developed was to supplement common law. We're going to see why they had to be developed and why courts of chancery were raised. So during those days, the common problem is that the common problem with this common law, which was the only law applicable then, is that the remedies it provided were inadequate. And in other instances, it had no remedy at all. So in an instance, for example, that you fall in a manhole that has been erected by the city council, the court is likely to award you general damages for that, for the injuries suffered. But the problem with that is that tomorrow someone else is going to fall there. So the remedy of damages is going to be inadequate. Or if you've agreed to buy property from someone, you've paid them money, they just haven't transferred the property to you. And then it turns out that that property is of high value or is in an area where you cannot get another property of a similar kind. The problem with that is that even if you're given general damages for breach of contract and your money is refunded to you, this money that you're receiving is not going to help you compared to if they were asked to do specific performance to transfer it to you. Same case with the manhole. If someone else is going to fall there tomorrow, about 10 people have fallen there. We can't keep giving damages to each other person. At some point, the court should get a tailor-made decision. And a tailor-made decision in this case is supposed to be a mandatory injunction. It's supposed to be a mandatory injunction to tell this city council, so look here, what you're going to do is that you need to cover this manhole or make it safe, fence it off, make it safe, just make it safe for people so that no one else is going to fall there. So common law provided remedies that were inadequate. So they'd go to court, but they're not getting help. So we're saying if someone grabbed your land, the courts might award damages similar to the value of your land. But if you can't find land of the same value or in a similar location, and say it is a beach plot, for example, this court is supposed to give you an injunction so that your land is returned to you. It is also supposed to cancel that registration if they have made a transfer to themselves in a fraudulent manner. That registration is supposed to be canceled. Registration in favor of the land grabber. So for these reasons, equity came along to remedy the inadequacies of common law and to make the law a little more reasonable, making some tailor-made remedies here and there, so that when a party goes to court, they do not come out having not been helped. So courts of chancery were established in 1470. So the courts of chancery were the courts of equity. And they were presided over by a Lord Chancellor, who was a custodian of the King's will. So this was a clergyman, and he based his rulings on the law of morality and justice. So he wasn't bound by procedures of courts, and he had power to summon witnesses. So if he summoned you and you were not able to attend, or you did not attend without good reason, there was a threat of imprisonment. So the citizens were dissatisfied with the decisions made by common courts, common law courts, and what they did is that they went back to the king. So the king decided to start hearing the cases himself. At some point, the king became tired, overwhelmed. He appointed a clergyman in the name of the Lord Chancellor. And what he'd do is that he would hear the appeals while applying the law of justice and morality. So the people made a petition to the Lord Chancellor on grounds that, one, the common law courts never provided for certain wrongs. For example, trusts were never recognized. Someone is holding land with the promise that they're supposed to transfer it, say, to children of a deceased person. But common law never recognized this. Yeah, remedies in certain instances were not satisfactory. So, for example, in contract, the only remedy that was available was damages. Things like specific performance and injunction, they never existed, they were never known. So they did not exist in the law as we know it today. And common law courts did not act impartially. They did not act impartially. So they were under pressure, influence of bribe much of the time. And this created a big problem that these common law courts have become corrupt. They're working under pressure, they're working under influence of other people. So there was a need to change this. So what happened? Doctrines of equity were formed. Now, and in the courts of equity, these were the laws that used to apply. The first is that he who comes to equity must come with clean hands. That equity regards as done what ought to be done. Equity aids the vigilant and not the indolent. Where equities are equal, the first in time prevails. He who seeks equity must be ready to do equity. Equity looks to the intent rather than the form. Equality is equity, and equity follows the law. We're going to look at this one by one. So, where we are saying he who comes to equity has to come with clean hands. What we are saying rather is, in relation to that case, where you are seeking an equitable remedy, say, for example, someone is trespassing on your land. If you see that he has trespassed on your land, and you decide to take matters into your own hands, find him and assault him, or do other things that are wrong to this person in relation to that transaction, then you'll not be having clean hands. So when you're going to court, seeking an injunction, you need to go there while you yourself haven't done anything that is wrong in relation to that transaction. So you must be clean. You must be someone who has already acted fairly in that transaction. If it is a matter for sale of land, sometimes you yourself have not paid for the property. You're in default. So for you to get an injunction will be a tall order. Number two is equity regards as done what ought to be done. So, for example, if you have sold your motor vehicle, but you haven't conducted a transfer over the same, the courts are not supposed to penalize you who sold the motor vehicle for an act. For example, the motor vehicle causes an accident. The court is going to look as done what ought to be done. They're going to treat the case as if you had already transferred your motor vehicle. And this is what is supposed to be done. So it is equitable to consider that the motor vehicle has been sold and transferred, where that is just the only thing that is remaining. Sale of land, you haven't transferred, but some rights will accrue to you as a purchaser for value, even if you haven't transferred that property. So this will apply to the extent that the law allows. Equity aids the vigilant as opposed to the indolent. So in matters of equity, so for example, if you want an injunction, you're not going to wait from the day someone has come onto your land and started treating it as his, living there, erecting a house, you're not going to wait for 10 years to approach the court for an injunction. So this delay, first, the more you delay, the more the court is not going to give you the kind of remedy that you're asking for. So it aids the vigilant and not the indolent. In the exam, they might refer to this as the Doctrine of Larches. So you can be asked a question, for example, describe how the Doctrine of Larches applies in relation to the Doctrines of Equity. So do not be confused by the word Larches. Larches simply means delay. So in another way to say equity aids the vigilant as opposed to the indolent is to say delay defeats equity. So when you're doing your own research, if you see delay defeats equity, it is the same thing as equity aids the vigilant as opposed to the indolent. So where equities are equal, the first in time prevails. Where both of you are regarding yourselves, saying as transaction for sale of land, both of you are claiming yourselves to be purchasers. So what the court is going to look at is who came first. So you two equally being purchasers, the two of you equally being purchasers are equal. Your equities are equal. So the first in time is the one that is going to prevail. So they're going to make a decision in favor of the person who came first to this transaction. He who seeks equity must be ready to do equity. So this relates to the issue of fairness. When you're seeking equity or remedies or equitable remedies, so to say, you're also supposed to be ready to be equitable. In this sense, you're supposed to be ready to follow the decisions that the court will give. You need to be ready to abide by the court's decisions. If the court says this is what fairness amounts to, so you need to be ready to do that. So the court is going to assess the readiness of this other party or your readiness as the party seeking the orders in equity. They're going to look at your readiness to do equity before they grant these equitable remedies. The other is that equity looks to the intent rather than the form. This closely follows doctrine number 2, that equity regards as done what ought to be done. So equity is going to look at, for example, if you are having a contract for the sale of land and you name a party wrongly, a party is supposed to be named as a purchaser or buyer, but you name them in another manner that doesn't say buyer or purchaser. The court is going to look at the whole contract. The court will disregard the form, that it doesn't look like a contract for sale of land, and just consider the intent of the parties, the intention of the parties. What did the parties want to create? So we look at that, the court will look at that, the intent, the intention of the parties, as opposed to the form. So the form can be wrong, but the court is more interested in what parties intended, and that is fairness. Equality is equity. Yeah. Where, say, someone is holding land under customary trust, it is required of him by the law, him or her, by the law, that if he's holding land in trust, if, say, the firstborn child, as customs of other people are providing for, is that when transferring these properties, it will not be equity if this person decides to transfer a little more to himself. So when they do transfer a little more to themselves, that is not going to be equity. And the trusts are based on the law of equity. So therefore, it will be the court's decision that it is not equitable to share the property in a manner that is not equal. Equity follows the law. So in relation to all this, the courts of equity are not going to go against the law in an attempt to carve out a remedy that is fair to the parties. The courts of equity will follow the law nevertheless. So where there is a law, say written law, that says this is what's supposed to be done in this area, that is what the court is going to follow. It is going to follow the law as it is, to not create laws for itself. So when these courts were formed, so initially they lived in harmony, and at some point, there was a lot of jealousy that grew between these parties, and these courts became bitter with each other. And the problem that happened this time is that the courts of equity were gaining popularity at a high rate. They became so popular that people preferred to go to courts of equity as opposed to the courts of common law. So at some point, King James, the King of England, had to intervene. So the king arbitrated this matter. It was arbitrated, and the king was advised to make a decision that where there was a conflict between equity and common law, is that equity would prevail as opposed to rather common law. It is not common law, it is equity. That equity would prevail in matters of this nature. So it was decided that equity law is going to prevail. So in Kenya, the courts apply both common law and equity within the same court. So this division does not exist. The separation between the courts of common law and the courts of equity does not exist. So what happens is that it is the same courts that are going to apply doctrines of common law, and it's still the same courts that are going to apply doctrines of equity. So to the extent that your case is going to require the application of common law, they're going to apply. To the extent that your case requires application of an equitable doctrine, the same is going to apply. So the judge or magistrate makes the judgment call, and also depends on the kind of pleadings that you've prepared to the court, or kind of application that you've prepared to the court. Where you're seeking an equitable doctrine, court is going to apply doctrines of equity. Where you're seeking a common law remedy, the court is going to apply common law. Sometimes you can be seeking both. So which is why we are saying To the extent that your case requires application of common law, they're going to apply common law. To the extent that it requires an equitable doctrine, it is going to apply accordingly. Now, we're going to look at remedies that are provided for under the Doctrines of Equity. We also call them equitable remedies. The first is an injunction. The second is specific performance. The third is restitution. And so we're going to look at first what an injunction is. So an injunction is an order which the court will generally refer to as an injunction, and it will be directed at a party, making it mandatory or directing them to take an action or avoid doing a specific action. If you're being accused of trespassing on someone's land, court is going to give an injunction. On top of giving damages, it will give an injunction and say, never step on that other person's property. So that would be an injunction, because damages would not be sufficient to help this person. There's no point paying someone damages today and you trespass on his property the following day. Or sometimes someone has settled on your land. So where court gives a mandatory injunction that this person leaves your land, then that is a remedy that helps this person. So it makes it mandatory for them to do or avoid doing a specific action. So the court can also order a party to stop what they're already doing. So it doesn't have to be something that has not been done. The court can stop you from doing something that you're already doing, or something that hasn't been done, but you intend that, but the nature of your actions shows that you're going to do them. So court can stop you from that also. So it can order a party to stop what they're doing, or order them to proceed with what they're doing and not stop. So if, say, parties have a right to obtain some service from you, and you look like you're going to stop them, or you have communicated your desire to stop them, then court is going to, if court gives an injunction, the injunction can say that you will not stop doing what you are supposed to be doing. So a party can obtain an injunction at whatever stage. So you can get it at the preliminary stage upon filing a case, or at any stage of a suit, or at judgment stage. So you can get it, you can apply for an injunction contemporaneously with the case. So you can file a plaint together with an application for an injunction. And court is going to hear the injunction prior to even making any directions regarding the case. And it is important that the remedies that have been sought at the preliminary stage in that application are also reflected in the main case, in the plaint, so that the court is able to make a determination on this same. So they can be made at any stage. So injunction continued is that these are the types of injunction. Number one, temporary injunction. So a temporary injunction is the one that court is going to grant to maintain the status quo. In this case, what we're saying is that the court is going to give an order that what you are doing, continue doing it. What you have not done, do not do it. Keep everything as it is until the court decides on this case. If parties are fighting over money that is in, say, a joint account, the court is going to say no one is drawing any amount from there until they determine the substantive issues before the parties before it. So it's very hard to get an interim injunction, mandatory injunction at this stage, in the sense that it is very hard for court to order someone to do something positive. For example, it is easier for court to tell a party to avoid demolishing a house, but it's much harder for the court to tell this person to build a house. So it is very hard for court to give a positive injunction at this stage, unless the case is very clear and extremely straightforward. So that is an aspect of practice. Once you practice for a while, you realize that. Prohibited injunctions. So these are injunctions that are telling a party to stop what it is doing or avoid doing something that it is contemplating to do. So as opposed to the first that we're talking about as a temporary injunction, this one is a prohibitory injunction. It tells you to stop what you're doing. And a prohibitory injunction can either be temporary in nature or permanent in nature. Mandatory injunction. This is a positive injunction. It is a positive injunction in the sense that the court can order you to do something that you were initially supposed to do, or now you have become reluctant to do it. So the court is going to carve out an order in the nature of a mandatory injunction. Like we gave the example of that manhole in the county council or city council. That's this manhole, when the court tells the city council to fence off it or cover the manhole, that is an order in the nature of a mandatory injunction. So they're telling you, do this thing that you're supposed to do that you haven't done or you're looking reluctant to do. There's a quia-timate injunction. Quia-timate injunction is more or less an injunction raised out of conjecture, in the sense that you already anticipate that your right is going to be infringed. And with that suspicion, you only carry that suspicion to court and tell the court, this person is about to infringe on my right. So therefore, what I'm asking the court to do is to stop him from infringing my rights in that future date. So you have already, you go to court with that thought in your mind, that suspicion in your mind, and you're going to prove that. Why do you suspect that this person is going to infringe on your rights? Say somebody, you know that someone has instructed a group of young men to demolish your house. So you can get a quia-timate injunction in the sense that this destruction that is going to happen should stop. So that is what is called a quia-timate injunction. Ex parte injunction. Now, when we're referring to the temporary injunction that you can bring to court even before, at the point of filing the case, so that you get a temporary injunction as the case goes on. So those injunctions are most of the time obtained ex parte. The law allows you to obtain it ex parte in the sense that in absence of the party to whom the injunction is directed. The reason being, the moment you serve this other person with a hearing notice or that application, they are likely to either evade the court or take an action that is going to defeat that injunction even before the court decides whether you're getting that injunction or not. So if, for example, you're taking someone to court because they're about to demolish your house in 5 days. Now, if you serve them with the injunction or the injunction application, what they're going to do is that they're going to demolish it today before the court hears even your application for an injunction. So which is why the law allows you now to go ex parte without the attendance of the other party or the participation of the other party. So this one is granted in absence of the party to whom the injunction is directed. They do not participate in the decision-making process that leads to these orders being made. The last one is a Mareva injunction. So Mareva is an injunction that is granted to freeze assets of a party even as court proceedings continue. So a Mareva injunction is basically a freezing order. I believe we have one more. This is an Anton Pillar injunction. Anton Pillar injunction is an order that allows a party, most of the time these are government agencies, to enter a property and seize assets that are going to be used as evidence or as part of an investigation. So if KRA is suspecting that you're doing evasion of tax, they're going to apply to court for an Anton Pillar order. And what is going to happen is that they're going to be awarded this, they're going to be given this injunction in your absence. So Mareva injunction and Anton Pillar injunction are most likely ex parte injunctions. In most cases, they will be ex parte injunctions. Because if an Anton Pillar injunction application is served upon you, that they're going to investigate your place to seize assets, from your place and use them for investigation, the most likely thing that you're going to do is that you're going to take off with these assets. So they're never going to get that evidence to prosecute you. The next remedy, now we're done with injunctions. The next remedy is a specific performance. Before we go there, we can also say another type of injunction is a permanent injunction. A permanent injunction is an injunction that is granted once the whole case has been decided. So if it's a case of trespass, the court might as well give a temporary injunction or an interim injunction so that during the hearing of the suit, you are not trespassing on that property. However, once the court has decided that you do not own the land in any color or right, you never purchased it, you are not a tenant, you are not a licensee, you haven't leased the land, you basically have no business being on that land, the court is going to give a permanent injunction, or a permanent injunction, as opposed to a temporary injunction. So now we can go to specific performance, having looked at injunctions. So now specific performance, I'll give an example before we even describe it. So if you're involved in a contract, an example for sale of land, and the seller collects money but refuses to transfer the property to you, it's going to be a sufficient remedy to order the seller to pay you damages for breach of contract or give you money back. It's not going to be a sufficient remedy because what you had agreed that you wanted was the property. Sometimes people make decisions based on an agreement for sale. You have agreed with your financial institution that you're going to get a loan and do this other business on the side, all based on the understanding that you have land that you have purchased. So it's not going to be a sufficient remedy to order that you pay damages for breach of contract. What if you're not able to get another one in the same area or of similar value or similar type of land, for example, for the same purpose? Maybe you wanted to construct a large-scale production industry. What are the chances you're going to get another property of that size? Being that land is of limited nature, is a limited resource, is a scarce resource. So the better remedy is that you get specific performance. Now, as we said, in this case, it will be better for the court to order that the seller signs the transfer forms that are now in your favor, transfer in your favor, and hand you the title document. Maybe it could be a certificate of lease, certificate of title, or title deed. So once they hand this to you, this is what will be called specific performance. Specifically perform your part of the contract. So that's what it is, a specific performance. You're being told, perform specifically in the manner in which you had agreed. Perform your part of the contract in that manner. Now, there are cases where a party deserves an order in the nature of specific performance. And there are also cases where they do not deserve an order of specific performance. So we're going to look at cases where the court is likely to give specific performance. So number one is where no other remedy is going to be sufficient. As we've said, in a contract for sale of land, or say you're purchasing rare china. Rare china is rare utensils. For example, you're importing utensils that are very hard to find elsewhere, right? So you've agreed for the sale of that. So the court is likely to grant specific performance for those things that are rare. We're going to see that. So where no other remedy is going to suffice, where damages are not sufficient as a remedy, you're likely to get specific performance. If damages are an inadequate relief, for example, so as we've said, where other remedies are not going to suffice, where damages are an inadequate relief, court is likely to order specific performance. Where the subject matter is rare, not easily found, you're not able to find this other thing elsewhere to buy it. So specific performance is going to be granted. Where there is no standard of ascertaining the actual damage, court is going to grant specific performance. So sometimes when you look at land has several other things. There are matters like speculation, matters like potential. It is a resource, a factor of production that has several different other characteristics. So it is very hard to ascertain the actual damages that have been suffered by a would-be purchaser. Someone has decided to relocate to that area. Somebody has made plans that in the next year he's going to live in, say, Kitui, where he has bought this property. So specific performance would be better because land has different other characteristics that is so hard to ascertain the actual damage on that property or in relation to that transaction. Where an article is of special value, then a remedy of specific performance is going to be required. Say you're buying an instrument that is under patent, that is patented. So it is very specific. And an instrument that is patented would be an instrument that has come to solve a problem in the industry. So something that makes, for example, makes works easier. So this would be of special value. Say, for example, in the initial, in a transaction where Bill Gates is selling Windows to you, selling Microsoft to you. So it is of special nature that it is very hard to determine what the value would be is of special value because majority of people are using the same application. So it is of special nature that the court would rather give you specific performance as opposed to any other remedy. Where the article is not an ordinary article of commerce, it's not a thing you just go out there and buy. So then, in which case, that would require specific performance. Where the property is held by the defendant as an agent of the plaintiff. So you're holding some goods as my agent. The better remedy, because you're just holding them as an agent, is to tell you to perform your duties as an agent and give the property to me. You're holding it in trust or as an agent. When dealing with immovable property like land. Now, still on specific performance, there are those cases I've said that do not deserve an order in the nature of a specific performance. One is where compensation with money is an adequate relief, so you can get paid and move on. Where specific performance cannot be reasonably performed. Say it is a contract for the provision of services. This person is a pilot and he is unwell today. So even if the court gives 10 orders that he performs specific performance by flying people to Russia, it is not reasonable that so it is not going to be reasonable that this person performs the contract specifically. The reason being that this person, if he's unwell, even if orders come in fact, the orders endanger the people being flown over there, as opposed to them not being provided. Where the contract can otherwise be put to an end as a remedy. Say it's a contract for employment. Sometimes it makes more sense that parties terminate the employer-employee relationship as opposed to forcing someone to come work for you. And that is sort of some form of slavery. And therefore, the court is not going to award this. So where the nature of the contract would require supervision or is of a continuous nature. This works very well in a case like a contract for provision of services. If the court cannot give an injunction, a specific performance for someone to be doing the same action every other day for the next 30 days. Because this would require supervision of court and is of a continuous nature. So the courts are not in the business of supervising people, and therefore, if it requires court supervision, the court is not going to grant an order of specific performance. We have restitution now as the other doctrine, the other equitable remedy. Now, restitution, it means you're taking the person back to the position they were in before the action in tort or contract was committed. So, having done restitution, the other party should be left in a position they were before the action was taken. So, if the plaintiff's items of trade are taken wrongly by an auctioneer in the process of enforcing a court order, so the court is likely to order restitution, put them back in the position you got them, so that restitution will have sufficed as a remedy. So that's it about equitable remedies. And now we look at the second subtopic of our day today, we're going to look at African customary law as a source of law. African customary law is one of the unwritten sources of law in Kenya. So African customary law applies and is recognized in Section 3 of the Judicature Act, Cap 8 laws of Kenya. So it applies in these scenarios. Number one, in civil cases, in a dispute of a civil nature between individuals, and it cannot apply in criminal cases. And so when you enter into a transaction where one of your parties is of African origin, then customary law is likely to apply to the extent that it is applicable. And it mainly applies to matters of marriage, succession, and matters personal status. So it cannot apply in criminal cases. In criminal cases, there are requirement of codification, making it be written somewhere. I doubt that your customary law, if you're African, I doubt that your customary law allows you or is written in a specific document. I doubt that that applies. So customary law is unwritten, and it is basically witnesses who come in, experts in customary law who come in to testify on what customary law is or what the applicable customary law is. So it cannot apply in criminal cases. It cannot apply which is repugnant with natural justice and morality. So basically, if it is inconsistent with natural justice and morality, it is not going to apply. If it's inconsistent with any written law, in the sense that you compare it with written law and you're like, this practice does not apply anymore, then it is not going to apply. It should also be reasonable for it to apply. Now, Section 2 of the Kenya Magistrates Court Act refers to claims that can come to court under customary law as the following. Land held under customary law. So in most of our communities, we have a manner in which land is transferred under the doctrine in England known as primogeniture or primogeniture, that land is transferred to the eldest son and is held by him in trust for the other people. So it is held under customary law for the other siblings. So this, when it comes to court, court can apply customary law. Matters marriage, divorce, maintenance, or dowry. So in matters of marriage or divorce, and the issue becomes, what is it that this person has done that is so wrong that they have to be divorced? So in citing grounds for divorce, and to the extent that the ground is wrong in your custom, and it's still consistent with the Marriage Act, it is going to be upheld as a reason for divorce or a ground for divorce, maintenance or dowry. So dowry is another form of proving that a marriage existed prior to deciding that a divorce can be granted. There are communities that regard seduction or pregnancy of an unmarried woman or girl as taboo. So such matters the application of African customary law can be used. So there are people who demand reparation or some form of damages where you impregnate an unmarried woman or girl. I believe parties are moving away from these customs, so it might not be applicable presently or towards the future. Enticement of or adultery with a married woman. So this also applies. I think it will be a good ground for divorce because it is consistent with the Marriage Act. Matters affecting status, in particular the status of women, widows, and children. And this includes guardianship, custody, adoption, and legitimacy. So this will also be applicable in our courts as a customary law.